Hello, and thank you for listening to another episode of Your Life Simplified. My name is Brian Leitner, and I'll be your host of this episode. In today's episode, we're going to talk about estate planning, and specifically 7 reasons why your estate plan may be weak. It may not be up to par. It may not be the plan that's going to help you accomplish what some of your goals are. I'm excited to have a reoccurring guest on the show. His name is Jadin Winberg, and Jadin is the Vice President of our Estate Planning and Trust Services group here at Mariner Wealth Advisors. So Jadin, thanks for coming on the show today.
Thank you for having me, Brian.
So Jadin, I know that people, a lot of times they'll get confused as it relates to estate planning because there's different intricacies about it, right? There's the basic documents you need for estate planning to protect your family, your loved ones, to help you carry out your wishes. And then there's the idea of wealth transfer and truly transferring wealth down to potentially different generations or transferring money to certain causes and things of that nature. And earlier this week, you and I were talking about just some of the areas of estate planning specifically and where you find on a regular basis that some of the documents are either out of date or there's something that's just simply off. Even though individuals themselves may say, I've already done the plan, I've already met with the attorney, and everything's in place and I'm all good. And so I thought we might do this morning is talk about, again, these 7 reasons why someone's estate plan is weak. So if you're ready to go.
Let's do it.
So the first reason your estate plan may be weak is because you don't have all of the basic documents in place. So can you talk about the basic documents that our clients and prospects likely need?
Absolutely. So I like to say there are key documents, as you mentioned, to estate planning. And obviously, these are documents that will apply to virtually everybody's situation. As your asset composition, the complexity of your asset composition increases or the value of your estate increases, you would add to these documents and add to your planning. But from just your basic document perspective, there are a couple things. One is a will. So from a basic document perspective, there are a few that I say everybody should have. One is a will, and the will is a directions to the probate court telling them what is to happen to your estate when you die. The other key thing that it does for our clients who have minor children or they care for incapacitated children is guardians. And so that's a really important component of a will. That's going to tell the probate court who's going to have responsibility for those individuals when you pass away. Next is a revocable trust. I say everybody should have one of these. It's not a function of net worth or anything like that. And it is a document that's going to say how these assets are going to be managed during your lifetime. You're the grantor, you're the trustee. It's reported under your tax ID number. A lot of flexibility with it. Really nothing changes during your lifetime in regards to how those trust assets are managed. But importantly, at your death, what's going to happen is it's going to be a seamless transition of those assets to that next generation of beneficiaries without having to go to the probate court. And so it's a customized document. You can put any sort of dispositive provisions you want in there. You're going to select your successor trustees who are going to take over once you're unable to manage that trust on your own. And so whether that's incapacity or death. Next are your powers of attorneys. So there's a couple different types. One is a financial power of attorney. And like it sounds, it's going to be somebody who takes control of or has responsibility for any financial aspect of your life if you are unable to do so. The other type of power of attorney is what's called a healthcare power of attorney. And so that's, again, like the title says, it's going to deal with any health-related care needs, that type of thing for if you are unable to do that. And so where the financials dealing with your finances, the healthcare power of attorney is your health and well-being. And then finally is what's called a healthcare directive. And that's sort of a type of power of attorney for healthcare, but it's very specific in terms of situation. So end-of-life care, what you would want to happen, what if you found yourself where you're needing a feeding tube or you couldn't breathe on your own, and so you needed machines and medical care to help with those kind of essential life functions. And these are instructions that are telling the medical care providers what you would want to happen if you found yourself in these very specific types of situations.
So, Jade, appreciate that. Let me just maybe recap that really fast, right? You're talking about the will itself and how that's going to help you pass your assets down to whoever that might be. And also, again, guardians and how you want those children raised. Otherwise, the state will really make that decision on who's going to raise those children, what that looks like. And every state is going to be a little bit different. You also talked about the living trust, and I think we're going to talk a little bit about what the trust does and how that helps distribute assets, and doesn't tie any of those assets up in probate, which is really that process of approving the will where things can get tied up and for up to 9 months, depending upon the state. There are additional fees and so forth, so it goes right to. You have the 2 powers of attorney, whether that be healthcare or financial related. And then lastly, you talked about the healthcare directive, which is also known as the living will, just to make sure that everyone understands the nomenclature and vernacular. Is that
Absolutely.
accurate? Okay. All right, that's great. That's a great sort of basic understanding of the documents that we need to have in place. And, I'll bet there's probably some folks out there that have that all buttoned up, and that there are others that say, maybe I have 2 out of the 3, and, maybe I'm leaving something out. Lastly, one thing that maybe we didn't mention, maybe I cut you off, is just the HIPAA documents themselves, right? So those of us that have gone to the doctor in the past, 20 some odd years, we know we need that in place in order to share information, especially if you have kids that are off to college. Right. We always recommend that
Absolutely.
That they have those in place, because if mom and dad rush up to the university and want to know that they're figure out what's wrong with their child, the doctor can't share that information unless there's a HIPAA on file. So critical documents. So thank you. Okay. Yeah, then we talk about, maybe the number 2 reason that your estate plan might be weak is, the beneficiaries that you selected, are they the right beneficiaries? And have you communicated what's important? Can you talk a little bit about that?
With beneficiaries, it's always a sensitive area for our clients, and it runs a spectrum in terms of the information that they want their beneficiaries to have in regards to assets they may be receiving through their estate plan and things of that nature. And so that's one of those areas where obviously you can really structure that communication in a way that reflects your values and how much information you want those beneficiaries to have. And so whether that's you're bringing them along through that financial planning process and letting them introducing them to your wealth advisor, and having those discussions now about what does it look like to properly manage your money and plan and that types of thing. The other end of that spectrum is we see a lot of clients where privacy is a really big issue, and they're very sensitive to not wanting their beneficiaries they're not wanting to create this sort of trust fund mentality that we see in our industry.
Sure.
Where it can
spoils the kids, or
disincent them from being productive and that type of thing. And so wherever our clients fall on that spectrum, it's just important that that's reflected in their estate planning documents, and that we're, as the wealth advisors and as their fiduciaries, we're helping them walk through that process with those beneficiaries and have those conversations.
Yeah, I think communication is critical, and it's a topic in which we spend a lot of time educating clients on, and then sharing what I would refer to as sort of the best practices, and best conversations I think we have with families. Communication and money, they generally don't go hand in hand. We don't talk about these things on a regular basis. We don't talk to our best friends. We don't talk to our family maybe about how much we're worth or what debt we have and things of that nature. But as it relates to communication, from what I've heard in conversations and just being in a lot of these meetings, mom and dad might joke to Junior about, don't worry, when you're no longer around, you're going to be taken care of. And Junior thinks he's getting millions of dollars maybe. And the reality is mom and dad are going to give him maybe a lot less than that. And they think that's, so there's room for interpretation there and expectations. And so that's one reason that I think communication is critically important. But also mom and dad, to your point, they don't want to spoil the child maybe, or the children. And they believe, 50% of their wealth is going to go to charity or something of that nature. And being able to have that conversation today versus in a time of grief or after the fact, getting everybody on the same page, I think it's really important. Mm-hmm. And I think what's even more interesting is if you think about this, depending upon where you live and legal age in terms of when you get your license, mom and dad may sit down with their son or daughter and talk to them about the responsibilities now that you have a driver's license. You shouldn't text, you shouldn't speed, you shouldn't go out with, a bunch of friends in the car and do crazy things. And there's a time and a place to have that conversation because there's a law in place when you get a license. But, I don't know a particular law that's in place, perhaps a best practice, where you should sit down and say, hey, listen, let's talk a little bit about our wealth, even if you're not talking about dollars and cents, but maybe just percentages and wishes. And so I think that does get missed with beneficiaries. So again, that's maybe another area in which the estate plan maybe needs to be buttoned up.
Yeah, and sort of an offshoot of that we see is if you have particular types of assets. So if you have a closely held business interest, you have farmland, you have something else that takes a unique interest or skill set to manage those assets. I think those situations are particularly important in terms of setting expectations for those beneficiaries if they are going to be receiving those assets, what that looks like, making sure they're equipped to handle them, making sure they want to take on some of that responsibility.
That's an excellent point.
In regards to those types of assets. So again, whether that's a family farm or obviously with the closely held business, it's we see they may want one child to receive that, or they want all their children to be involved. Well, that may or may not be what their children want. And so to flesh that out on the front end, I think is much more beneficial. If it falls within your values and things in terms of communicating to your children and grandchildren.
It's an excellent point. I mean, because in that situation where one child is going to get maybe the business, and how do you, if you want to equalize, that estate or that, what does that look like? And the more time you have to plan for that, I think the more efficient it could be for everybody, right?
Absolutely.
So the third reason that your estate plan might be weak is that you're not using a trust. And so you talked a little bit about the revocable trust. Can you dive a little bit deeper as to why someone would want that? I mean, you hear conversations sometimes with clients that say, well, what does that cost? Or do I really need to pay for that? And just any thoughts from that perspective?
Sure. So, the thing with trust, obviously one of the big benefits of them is that you avoid probate. And so probate it's a court process that you would go through when you pass away, and it's determining what is happening to your assets. There's two ways that it gets passed through the probate court. One is if you have a will, your will is going to tell that probate court what happens to your assets. If you die without a will, every state has laws which say who gets your assets and what percentages and those types of things. And so the downside to that process, one, it can be timely. So depending on what probate looks like in your particular state, it could be 6 months, 9 months, or longer. And some of those are statutory timelines in terms of there's not really a way to speed them up artificially. They're public. And so for a lot of people, that's, that privacy is very important. Again, as we previously spoke about, not only within your family, but within anyone in the community that might have an interest to see what happens with your estate. And so it is public. Anybody can go down to the probate court and pull your probate file and see where, who got what. It can be costly. And I know the cost varies. Each state has their own cost structure around it. Some jurisdictions, it's not as expensive, and others, it could be up to 10% of the estate. And a lot of places, it's a substantial amount.
10%?
10%. It can be it's sort of a tiered fee. It's a statutory fee in some jurisdictions, meaning the attorneys and the executors get to take that. It's not, it doesn't matter if they spend no time or a lot of time in that state, they're going to be awarded those fees. And so that's probate. If you want to avoid that,
sounds like you do.
Absolutely. A trust is a great way to do it. And so a revocable trust, it's a document that you're creating. You can put whatever parameters you want in that document in terms of leaving those assets to your spouse or to your kids or grandkids. There's really no limit to how you would structure that, other than you can't have things that would be considered illegal or things like that where a court would strike those out. But outside of anything illegal, you can really be very creative with how you're structuring those inheritances, instilling your values, whether you want to have children working and incent them to work and be productive. You can do things like that in a trust. You can also do special needs provisions. So if you have a child who's going to need additional care, if you're no longer around to take care of them, you can build these types of things into your trust. So it's a very customizable document. It avoids probate again. And so the caveat to that is you just need to make sure that you're titling assets into the trust. So it is actually a an entity, if you will, that does own assets and would take title to assets. So deed your real estate into that. You could do that through a beneficiary deed if you want. Investment accounts, things like that. You would just want to make sure you're titling in the name of the trust. The other important thing is it provides, so obviously at death, but it also provides during times of incapacity. And so it's similar to the power of attorney. If you were unable to care for yourself and make decisions for yourself, that trust is going to provide some protections during those times.
So all great points. I think one of the other things that we always talk about is the fact that you basically have the ability to make decisions today and control those decisions from the grave afterwards. So you can make sure, regardless of what happens, that your wishes are carried out. And to me, that's peace of mind, and it is absolutely worthwhile to go through that process and speak to a wealth advisor who would then work with an attorney to draft those documents. And I think sometimes we get confused about, because there's so many different types of trust. With the revocable trust, I mean, that individual, that grantor, if you will, the individual that's creating this has complete control of those assets.
Absolutely.
In every sense. And so they're not gifting those assets to an entity where they would lose that control. And I think that's really important too when we think about these things. And you had mentioned something just a minute ago where you mentioned titling of the assets. I mean, that onto itself is probably another reason in which estate plans might be weak. But can you talk a little bit about why you need to retitle assets and make sure that they are up to date when you're doing estate planning?
Sure. So titling of your assets, as you mentioned, it's a very important component of estate planning as well. And so, titling is obviously, you can structure that different ways to where whether you have jointly titled assets that your joint title owner is going to take control of those when you pass away, to having, depending on the type of asset, you might be able to have a transfer on death title. So a car, for instance, can have a TOD on it. And then obviously if you're using trust, you want to make sure that, a revocable trust, you want to make sure that assets that are eligible to be titled in that trust, so essentially anything other than like a non-qualified or qualified account, you would want to make sure you're titling that through your trust. And because again, that's how you're ensuring that assets are actually getting funding into that trust and avoiding probate.
Thanks, Jadin. The titling is critical. I know from an advisory perspective, if you will, when we look at someone's balance sheet, when we look at someone's brokerage statements and things of that nature, once we see that they own A, B, and C investment and it's in their own name and it's not held in a revocable trust, I mean, that right away gives us an opportunity to bring that up and talk about some of the benefits and maybe understand why it's not, right? There may be a reason or two why it isn't, but for most folks that we work with, it probably does make sense to have that titled in the name of the trust. So.
Hey, this is Scott Sturgeon. I work on the team that makes your life simplified a reality. We'd love to have more information on our listeners so we can ensure that we are tailoring content to what you're interested in. For the next several episodes, we are going to give away a pair of Apple AirPods. Being considered for the giveaway is easy. Simply email your age, state you live in, and 3 topics you'd like us to address in the future to podcast@marinerwealthadvisors.com. We will pick a winner at random during the next several episodes from those who email us. Again, email your age, state you live in, and 3 future topics to podcast@marinerwealthadvisors.com. And now, back to the show.
So the fourth reason that your estate plan is weak, you're not able to locate your documents. And so, we hear this from people all the time. Any suggestions on that front?
Obviously you want to make sure that you have your documents in a secure and safe location. And so for many people, that might be a safe deposit box at a bank. A couple things that are nice about that. Typically, when you do pass away, banks will allow an executor to come in and do what's called a will search in a safe deposit box. And so they will actually accompany them and let them look through that safe deposit box to try to find, to locate an original copy of the will. So an individual or your executor or successor trustee is not having to dig through your files at home and crack the code on a home safe or something like that to try to locate those. Attorneys sometimes will keep copies of the documents for their clients, and that's dependent upon the attorney's practice and what they're comfortable doing. The other thing I think is important for your successor trustees, or executors, those types of individuals, or whether it's a corporate trustee who is going to be taking over at some point, I think it's important to give them copies of those documents, or at least if they're redacted versions or whatever you're comfortable doing, but just something so that they're made aware that they could potentially have to take over that role, but then that obviously that they also have copies in their files, and so they don't have to spend a lot of time and energy trying to locate that information when you're no longer around to help them with that.
And I think from just a bigger picture perspective, these documents, a lot of times they come into place in a time of grief, and people are dealing with a lot of different issues, and now we need to locate these documents. And for a lot of folks, they don't know where they are, right? Part of it's in their closet on a bookshelf somewhere. Maybe it's with an attorney. Maybe it's in a safety deposit box. Look, in my personal opinion, you should be able to get your hands on your documents in 30 minutes, whether that's your estate planning documents like your wills, your trusts, I would say your tax returns, your passport, and things of that nature, all your important documents. And so that's why we use sort of Mariner GPS and our platform where we store those documents digitally for clients. So it is, they have access to it right on their phone. That is just one of those things that I think get missed. And I know that people will have sort of their own binders as well. And while I think that's okay, you have potential issues if there's a fire or something happens within the house. But the greater risk that I've seen is that the families can't locate these documents and they haven't been updated. I mean, when you think about all the weaknesses we're talking about, it's critical to note that a lot of people have a plan, or they believe a plan is in place, but if it's not updated on a regular basis based upon changes they've made, life events, tax changes, all different sorts of things, that plan is effectively inadequate and weak unto itself. So appreciate that. The fifth reason, there's no personal property memorandum. Can you talk a little bit about what that is so people know that?
So a personal property memorandum is basically a list that you're going to include with your will or trust, and it's going to specify who receives certain pieces of personal property. And so, believe it or not, personal property is often what families and kids will fight over.
The most,
the
right?
stocks and the bonds and all those types of things. That's easy to deal with in terms of dividing, and there's usually not a ton of sentimental value associated with those types of assets. But the personal property absolutely can be a problem. And so, depending on, again, it's one of those things. There's a spectrum there with our clients in terms of how concerned they are with who's receiving what and that type of thing. But absolutely, if you have wishes that certain pieces of property go to certain beneficiaries, you would want to do that in a memorandum. The other thing that I would at least encourage our clients to consider, if you have assets, personal property, things that you don't use anymore or you don't need anymore, and you're really just holding on to give to your beneficiaries, maybe consider doing that during your lifetime. And the benefit with that is it removes the possibility of that asset disappearing or causing conflict when you're no longer around and the kids and grandkids are having to go through your house and locate items and things like that. And so we've seen where a memorandum might list something to a certain beneficiary, and we can't locate that piece of property, and so it can create some hard feelings and things amongst the beneficiaries if they feel like maybe somebody got to that before they should have, or that type of thing, and or one sibling took it, and
right now there's plenty of stories.
It's obviously, again, if it's a situation where you're able and you're comfortable and you're really just holding on to it, just to hold on to it to give to them, you might consider doing that during your lifetime.
It's a great point. That's something I see missing in a lot of estate plans. So it's a great reason to have it on this list. Just a simple example. I mean, you could have a will, and maybe mom has some jewelry, and it's going to be split a third amongst her three daughters. Well, I want the red jewel and she wants the emerald, and how does that get divided? And just so having a game plan for, again, maybe not all of your assets, but some of the sentimental ones that could cause conflict. So excellent points. So the sixth reason your estate plan is weak is that you have the wrong people named in your document. So what are your thoughts about that as it relates to the executor, the trustee, the person that you're putting in charge of your healthcare power, and those individuals? What are your thoughts as it relates to that?
Sure. So we see a couple of different things. One, what we often see is it's out of date. And so the individuals you have named in there, for one reason or another, you don't have much a relationship with that person anymore. Yeah. And, or we see situations where clients might have their parents named as trustees and executors. Well, it's like, well, they're probably going to be gone before you are.
Yeah.
And so, those are, again, just out of date, not the right people anymore for one reason or another, don't have a relationship with them anymore. Those roles are it's a very high standard of care, being an executor, being a fiduciary, as a trustee, even a power of attorney. And so you want to make sure that you're selecting people, A, that have the competency to carry out those roles appropriately, and B, that they have the time to do it, because these can be very time-consuming tasks. The final thing is whether they actually have an interest in doing that. And so we find that a lot of times our kids or other advisors that they might work with, CPAs, attorneys, don't really have an interest in serving in that capacity. And so they never brought it up to them, during, hey, I'm going to put you in here as in this role. And so those are reasons to not, put somebody in there, an individual. I'm a firm believer in a corporate trustee. I think there's a lot of great benefits to that in terms of expertise. They have policies and procedures and processes in place to do this the right way. There's checks and balances with corporate trustees that you don't have with individual trustees. So whether that's regulators that look at what corporate trustees do on an ongoing basis from an administration standpoint and things like that, they usually have internal compliance folks that are keeping tabs. And again, you have professionals at the trust officer level and at the fiduciary officer level managing these trusts and making these decisions. Versus an individual, again, who doesn't necessarily have that expertise or interest or time to do it appropriately. And there really isn't a lot of oversight there on what they're doing. There's no governing agency that's watching an individual trustee. It's a matter of the other beneficiaries watching over what that trustee is doing. Right. And if they're not cooperating, if that trustee's not cooperating and is not doing tasks like they should, really the only recourse that those beneficiaries have is to going to court and forcing them to behave properly. And so that's a whole set of problems within itself. And so you can avoid a lot of that, not to mention the family dynamics, through a corporate trustee.
You bet. Maybe just a couple of points. You can have some middle ground as well there, right? You can have, a family member be a co-trustee. So, if that's important to what the family wants, they have somebody within the family that's helping to navigate, and then they make the trust company itself a co-trustee. So now, everything is being done on the up and up, and you sort of have maybe it's the best of both worlds for folks. Everyone's a little bit different. But going back to your point, the reality is when you name someone to be in this position, they don't necessarily know what to do. One of the things that we like to do is meet with everybody named in the documents. So there's a game plan, and we all understand up front what the wishes are of the family. So I think that's important. And maybe just another thought when we talk about documents themselves, I'm also thinking about as it relates to the healthcare powers and who you're going to elect. I mean, who's going to be that person that you want to have in charge of your health once you're in the hospital, right? Who is going to be maybe stubborn enough or willing to fight for your wishes when maybe the hospital has their own policies and procedures? I think that's just, you want to select the person that you obviously trust, but also has potentially the willpower and strength to fight where appropriate on your behalf. So different things to think about there. Mm-hmm. And so for the last of the 7, it is missing clauses that are in your estate plan. Can you name maybe just a couple of clauses that, again, people may say, I have the estate plan, but maybe if these 2 clauses aren't in there, it's going to give me reason for pause, or maybe something's incomplete.
Right. One of the emerging things I'm seeing, if you will, are what are called trust protectors. It can also be called trust advisors, special trustees. There's a whole bunch of different names for this role. But what it is it's not a trustee, but it's an individual typically who has certain responsibilities on that document if they're needed. And usually it's things in terms of modifying that trust, whether that's for tax purposes, or they can have powers to appoint and remove and trustees, things of that nature. But it builds a lot of flexibility into that document. So obviously during your lifetime, and if you have a revocable trust during your lifetime, that doesn't really matter because to your point earlier in the conversation, a revocable trust is going to allow you to make changes and do whatever you want during your lifetime. But once you're unable to make those decisions, whether incapacitated or have passed away, and that trust becomes what's known as irrevocable. And so that means, like it sounds, you can't change the terms of that trust. Well, if you have a trust protector or a special trustee or a trust advisor or whatever they're going to call it, that individual does build in some flexibility to that document. So I think that that's a really neat thing to have in there because there are often unforeseen circumstances that come about, later on down the road where you would want to make some changes and where it would make sense.
Or the company itself, the trust company, there's been a lot of change there, and all of a sudden, because we're talking maybe 20, 30, 40 years later, it's not the same company it was. So to be able to have somebody that decides we're going to move the trust from this place to this place, or this institution to this institution, might be a powerful clause to have in place.
Absolutely, right. The other thing that we're seeing, so jurisdiction, you're more and more, you're seeing a lot of variation amongst different states in terms of their laws of trust administration and how trustees, things they can do and beneficiary rights and those types of issues. And so at one point in time, it wasn't such a big deal. But again, now there's such a variation amongst different states that what we like to see in our documents, or if you're asking, if we're reviewing a trust for a client and making comments, one big thing that we're wanting to have included in there is language around situs. And so situs meaning what state controls the administration. Obviously the creation is where it's created, but mainly the administration and even the tax situs. And so having a clause in there that's granting some flexibility to the trustee to move that if you can. If you can locate a trustee in a jurisdiction that's much more favorable for one reason or another in terms of tax laws or administrative laws, having the ability under that document to move that is a great thing. And we're seeing more and more of that with trusts that are being created because, again, there's such the disparity between different trust jurisdictions in terms of laws.
And so, Jadin, when we create trust documents, via Mariner Trust, the situs that we use happens to be South Dakota because of the favorable tax laws, right? There isn't any state income tax there. Once you create a trust and once that's funded, it can last in perpetuity, it can last forever, whereas other states, at some point, they're going to make that trust end. So things like that, candidly, I don't think people know to even ask those questions. And so it's great insight. I greatly appreciate it. And I greatly appreciate having you on the show today. I know you're a busy guy, but I think, again, if folks can understand that, if folks want to take a step back, maybe after listening to this podcast and review what their current situation is, talk to their wealth advisor. If you're not working with an advisor here at Mariner, you can visit us on marinerwealthadvisors.com. There is a great deal of information that discusses this, roles and responsibilities of some of the key players, the basic documents, and a whole host of other information. So again, feel free to visit that information on marinerwealthadvisors.com. Jadin, thanks for coming in this morning. Appreciate it.
Thank you for having me, Brian.
We know that your time is incredibly valuable, and we hope you find this podcast a worthwhile investment of your time. Thank you for listening.
Mariner LLC, doing business as Mariner Wealth Advisors, or MWA, is an SEC registered investment advisor. Registration of an investment advisor does not apply a certain level of skill or training. MWA and its representatives are in compliance with the current notice filing requirements imposed upon registered investment advisors by those states in which MWA maintains clients. MWA may only transact business in those states in which a notice has been filed or qualifies for an exemption or exclusion from notice filing requirements. Any subsequent direct communication by MWA with a prospective client shall be conducted by a representative that is either registered or qualifies for an exemption or exclusion from registration in a state where the prospective client resides. For additional information about MWA, including fees and services, please contact MWA or refer to the Investment Advisor Public Disclosure website at www.advisorinfo.sec.gov. Please read the disclosure statement carefully before you invest or send money. Visit www.marinerwealthadvisors.com for additional disclosures. Mariner LLC, doing business as Mariner Wealth Advisors, will be giving one pair of Apple AirPods per episode to Your Life Simplified following the initial run date of this commercial, provided that there are submissions to choose from. Winners will be selected randomly. Each winner will be emailed to notify of the award and will be asked to provide a mailing address to mail the prize. The email address submitted will be subscribed to Mariner Wealth Advisors communications, including, but not limited to, our newsletters and email campaigns.